9:30. All right. Hi, everybody. Welcome to Webinar Wednesday. As you know, we hold these webinars every other Wednesday. So our next one, though, is not scheduled until August 10th. So yeah, that's what that is, 2 weeks away, huh? Seems like it shouldn't be, but yeah. So August 10th will be our next one. Lit up my mind. She is Laura Loretta is in Colorado, and she is a survivor and runs some support groups that do some really cool things that she's going to show us. August 24th, we're going to talk about Community Connects, Breathe the Recovery, and Peer Support Specialists in North Dakota. September 21st, we have an author coming. His daughter was in a very bad car accident. He wrote a book about that, so he's going to kind of tell us about her story. October 5th, we have autoimmune encephalitis. That was kind of a new term for me anyway. So it's a survivor from the Bismarck area, and she's gonna explain autoimmune encephalitis and kind of what happened to her when she was diagnosed with it. And then the other one we have scheduled is November 2nd. We have brain injury and audiology with Dr. Fire, who is out of Grand Forks. And I'm gonna throw that link in the chat for you guys that are here in person, but it's just ndbin.org/events/webinars. And that's where all of the upcoming are listed. And then that's also where all of our archived webinars are as well. So we record all of these. This one should be ready to go for you and up on the website by Friday, end of workday. So in just 2 days. And then there'll be a CEU request attached there as well if you would like CEUs for today. But I think that is everything, and we have Kelly Gores here today. She's with High Plains Fair Housing Center. So I will let her take it away.
Thank you, Carly. Yep, my name is Kelly Gores. I'm the Associate Director of High Plains Fair Housing Center, and thank you to the North Dakota Brain Injury Network for having us here today to talk about your fair housing rights and really focusing in on those disability protected class fair housing rights. So just a little bit about, oh, my slides aren't going to move again. Oh, am I sharing?
You are sharing, yes, but yeah, it didn't advance. I promise you guys we practiced.
We did. We were so good.
Oh, there you go. There you go. Now it's running.
Fun times. So High Plains Fair Housing Center, we are a private nonprofit organization, and we are here to promote fair housing, establish rights established by the Fair Housing Act across the state of North Dakota. We work to strengthen and ensure equal access to fair housing, so housing free of discrimination in North Dakota through training and education like this to let people know what their rights are and how to exercise them. We do advocacy as well. So we work to help people who are experiencing housing discrimination or think they might be experiencing housing discrimination to act as their advocate, either with their housing provider, or if they want to file a formal housing discrimination complaint, we can help them with that as well. And then the last piece that we do to really make sure that housing discrimination laws are being followed is we do a bit of enforcement and investigation, where we have a testing program and we have an investigation program that can really look into policies and practices that might be discriminatory to work to end those for future housing consumers. So that's about who we are. Who we are not are lawyers. So this is just my legal disclaimer that we always have to do, that I am not a lawyer. Nothing in this presentation is legal advice when it comes to those very specific fair housing questions or the situation that you are in. Sometimes it is best to talk to a lawyer. So for legal advice, contact a lawyer. But I can definitely tell you what the Fair Housing Act is, who it protects, how to exercise your rights and that kind of stuff. So today we'll really focus in on disability protections under the Fair Housing Act. But I will just cover briefly here in the beginning, just some basics about what it is, the protections and stuff like that, about fair housing, what housing discrimination is too. And then we'll talk about disability protections, the definition of disability under the Fair Housing Act, and we'll spend a lot of time talking about reasonable modifications and accommodations. as well as we'll cover assistance animal and housing, and then we'll just briefly touch on design and construction requirements under the Fair Housing Act. If there are any questions at any time, feel free to just ask them. I do like to keep things informal as well. I know it's harder on like a digital format, but I'm happy to answer questions if we have time, or we can have time to discuss at the end as well. So fair housing, what is it? It is a civil right. It is the right of an individual to obtain housing of their choice, free from illegal discrimination. And it means that you're protected by both federal and state laws, that you can freely choose a place to live without regard to your race, color, religion, sex, national origin, or because you have a disability or have children in your family. Some states provide additional protections, and we do. I'll cover those in a minute. But the Fair Housing Act was passed in 1968, so over 50 years ago. And at that time, in the public policy of the Fair Housing Act was to provide within constitutional limitations for fair housing throughout the country, and that no person should be discriminated against because of their race, color, religion, sex, disability status, or familial status, or national origin. So that's it's a pretty broad reaching law, right? Covers quite a bit of protected classes. I am going to skip the video. We do have kind of a video that talks about the history of it, but for the purpose of this, I'll kind of skip to how we got to why we needed the Fair Housing Act. But spoiler alert, it was really because of federal policy where we enacted housing policies through our federal housing programs that encouraged and really forced segregation in many of our northern cities at the time when Jim Crow was segregating our southern cities. So that's how we got to where we needed the Fair Housing Act. So the Fair Housing Act, because of that purposeful segregation by race and color, it had a dual purpose when it was passed initially. So the first purpose was to just eliminate housing discrimination altogether, but to really promote residential integration, to really replace those segregated communities with truly integrated communities. Housing discrimination includes blocking access to someone's housing, or kind of that differential treatment of people. So treating one renter or buyer differently because of one of those protected classes, or just outright denying someone the right to buy or rent a home, even though they can afford the property, and put in an offer for the property, all because that person is a member of a group that the law protects. Just want to briefly touch on this. The Fair Housing Law is broad. It covers all housing transactions and all transactions that occur within a housing rental or sale process. So not just the obtaining of the home, but it can be in the home insurance, it can be in zoning laws that a city passes, it can be in mortgage insurance, lending practices, those kind of things. So any kind of housing transaction is covered under the Fair Housing Act. Most dwellings are covered. There are some exceptions. We won't get into it too much, but unless it's a very small business operator or a housing provider that's operating under a specific reason, they might have some exemptions, but generally speaking, all dwellings are covered. And then we'll talk here about who's protected. So these are the federal protected categories. These are everywhere in the US, everybody has these protections, regardless of what your state laws are. So you can kind of think of this as the floor that everybody stands on, the protections. So initially in 1968, there was only 4 protected classes. That was race, color, national origin, and religion. So those were the original 4 ones. Quickly soon after, in 1974, they amended the Fair Housing Act to include sex protections. This was a time when the Equal Credit Opportunity Act also passed around this time. And before 1974, it was pretty hard for women to get housing or even a credit card or any kind of line of credit or loan, or rent an apartment without having a man on the application as well. So they added sex protections into housing as well to make sure that women could buy homes or rent homes on their own. Familial status and disability status were added in 1988, so about 20 years after it originally passed. This was added at the same time that there was a better enforcement piece added to the Fair Housing Act. So before 1988, it was pretty hard to get to get through a housing discrimination complaint because it had to go through the court system and it would take a long time, and people were often like wanted to move on, you know, after 1 or 2 years of dealing with it. So in 1988, they also added where HUD does the enforcement piece of the Fair Housing Act. So now when somebody files a housing discrimination complaint, they don't have to go through a court system and hire a lawyer. They can just file for free through HUD, and they can have their case investigated and try to conciliate it that way in a short time. So it's usually meant to be under 100 days that is dealt with instead of a long legal time. So that's also when they added that in 1988. So in addition to those state protected classes, we do have additional ones in our North Dakota Century Code written in. So we do have all the state ones included in our Century Code as well, but we also have receipt of public assistance. So being discriminated against because you receive some kind of public assistance, whether it's a housing voucher or Social Security, disability payments, that kind of stuff is protected. Age for those 40 and over. Marital status, in some cases, domestic violence. It's not really written into our housing code, but under a different clause, if you can't be discriminated against in your future housing if you are a victim of domestic violence. And then all of the federal bases are covered as well. Here in North Dakota, because our state laws are as good and really better than the federal laws, we have what's called substantial equivalency, and our state agency, the North Dakota Department of Labor, has the authority to investigate and try to conciliate housing discrimination complaints. So if you file with HUD, most often you can file directly with the Department of Labor, or you can file with HUD and they'll probably knock it down to our North Dakota Department of Labor and Human Rights to investigate any complaints about discrimination. A little bit about national origin discrimination. That really is differential treatment because of a person's ancestry, their ethnicity, maybe because of their language, their birthplace, culture, that kind of thing, to be treated differently in their housing or to be given different terms and conditions. Familial status, just wanted to expand a little bit on this as well, because it's something we see quite a bit of in North Dakota. Fair Housing Act prohibits discrimination in housing against families with children under the age of 18. This could be a family in which one or more children under the age of 18 live with their parent, or a person who has legal custody of the child or children. It could also be a designee of the parent or legal custodian with the custodian's permission. So this might be if somebody needs to be hospitalized for a long period of time, or somebody needs to, we've seen cases where people are deployed for war, so their children are living with their parents, so the grandparents are designees. They don't have legal custody, but they're still protected if they're being discriminated against in housing. So they're still protected just as that designee. It also applies to pregnant women and anyone securing legal custody of a child under the age of 18, as well as anybody in the process of adopting or fostering a child as well. Discrimination based on sex. One thing we saw nationwide was an increase of quid pro quo or hostile environment harassment, and which is illegal under the Fair Housing Act as well for any of the protected classes. But this is really that kind of basing housing on sexual acts, or just making a hostile environment for someone through sexual harassment or any kind of harassment based on any of those protected classes. But that was something we saw a problem with during the last pandemic when people were struggling to pay their rent. In 2020, Bostock decision made it so that it was a kind of an evolving field through the court system at that time, but gender identity and sexual orientation was only covered in some cases. But with that 2020 Supreme Court Bostock decision, where sexual orientation and gender identity was defined as being included under sex protections, it's now protected in housing as well. So that is something new that we're trying to get the word out, that you are definitely protected in your housing based on your sexual orientation or gender identity. And then there can be a disparate impact, which might not be discrimination on its face, but when a rule or policy affects one or more of the protected classes, it could have a disparate impact, something like domestic violence, which if they have special rules against people with who experience domestic violence or pregnancy, that can disproportionately impact women under sex protections. So some prohibited practices, so some things that are explicitly prohibited under the Fair Housing Act is based on those protected classes again. So federally, race, color, national origin, religion, sex, disability status, or familial status. If you are being, if someone refused to sell or rent to you because of one of those protected classes, or just refused to negotiate for sale or rent based on that, or otherwise make unavailable or deny a dwelling, that is illegal housing discrimination under the Fair Housing Act. Also prohibited is to discriminate in terms and conditions in the privileges or sale or rental of a dwelling, or to discriminate in the provision of services or facilities in connection with the sale or rental of a dwelling. This might be something where families with children or a person in a wheelchair are being told that they're going to have to pay a higher deposit or a higher rent than somebody who doesn't have children or is not in a wheelchair. It might be something where you're not being allowed to have accommodations in the application process based on a disability related need, something like that. So really that different kind of treating people differently in their housing based on one of those protected classes. I mentioned harassment is unlawful, and it's really because of this piece of the Fair Housing Act where it's unlawful to coerce, intimidate, threaten, or interfere with any person who is exercising their fair housing rights or enjoying any of the rights that are outlined under the Fair Housing Act. So really that harassment, but also retaliation. So if somebody does exercise their fair housing rights and they are retaliated against, the Fair Housing Act in addition protects against that retaliation. And then also something that we will see is just to represent to any person because of that their protected class that any dwelling is not available for inspection, sale, or rental when it actually is available. This is something that it might be steering where they're only showing people certain units. They might only be showing families with children units on a first floor instead of giving them their choice of where all of the available units in a building. It might be there was a story a few years ago back in Fargo where a person called to see a one-bedroom apartment and they made an appointment to go and see it, but this person was in a wheelchair. And when they got there, they went up to the rental office and the person said, "Oh, I'm sorry, we already rented that out. I should have called you. I totally forgot." So the person in the wheelchair just thought something didn't feel right. So they went back and had somebody else call and see if that apartment was still available, and it was still available. So when they saw that person in a wheelchair, they represented it that it wasn't available when it actually was. So those are kind of examples of discrimination. Sometimes it can be pretty explicit where they will just tell you something different that you'll have to do it because of your protected class. But oftentimes people will just get a suspicion that something doesn't feel right. And that's really a good time to give us a call and see if we can help figure out what's going on, if it is discrimination. And a lot of times it's just a waiting game where you might put in an application, you might be calling and waiting for a call back and nobody's responding to you because of that protected class, or they're just not getting back to you, kind of waiting for somebody else to rent the apartment or something like that. So that's often what it looks like. People can consider objective facts, so facts that aren't influenced by a person's feelings, interpretations, or prejudice. Things like, do you have ability to pay for the rent, the housing, and that kind of thing can be used when considering tenants. So that's just a brief overview of the Fair Housing Act in general. But let's take a closer look with discrimination in regards to disability status. But are there any questions, Carly, on any of that? Okay, for anyone?
Yeah, I'm not seeing any in the chat. You guys are welcome to type in the chat or come off mute if you have questions.
Great. Or even if you need clarification.
Yes, exactly. Yep.
Okay, so let's dig into disability protections under the Fair Housing Act. Disability discrimination cases are the most types of discrimination cases filed both in North Dakota and nationwide, with nationwide over 50% of them in North Dakota, probably over 60%. One of the reasons is because we'll talk about, in addition to just treating people differently because of they might have a disability, also refusing an accommodation or modification is considered housing discrimination for people with disabilities. But also a lot of people have physical and mental disabilities. So this just kind of shows that we're talking about 24% of people in North Dakota have some kind of physical or mental disability. So it is something that landlords and housing providers are going to run into more. And it is something that we want to make sure that people understand their rights, because there are over 140,000 adults in North Dakota who have some kind of disability. Housing laws for people with disability. So we're only talking about the Fair Housing Act here. And I don't want to confuse it with too much, but there are other laws that affect people with disabilities, or that protect people with disabilities in their housing. And that is Section 504 of the Rehabilitation Act. So any kind of housing provider that receives federal dollars for either the services, housing service, or whether federal dollars were received in the building of the structure itself, are covered as well under the Fair Housing Act, as well as Section 504 of the Rehabilitation Act. So things to think about might be when we talk about modifications, if they receive federal money, they might be responsible for making that modification versus somebody who doesn't receive money. But we'll talk about that more. So it could be both of those. The Americans with Disability Act, I think, is what people think of the most in housing, but that's really only covers any kind of public space within that housing. So this could be a rental office is covered by ADA, any kind of like community room, if there's even a place that can be rented for the public to come in, or any type of community space where the public could access it as well. That is covered by the ADA, Americans with Disabilities Act. And it really is the Fair Housing Act that covers even that does not the physical parts of the building within the living quarters themselves. So we mentioned that disability protections were included about 20 years after the Fair Housing Act passed. And it was really at that time where there was really trying to integrate people with disabilities more into our communities, instead of putting people away into hospitalizations or into homes or things like that away from their communities. And they realized that fair housing was going to be an important piece of integrating people and allowing them to just have independent living themselves. So they realized that people, made the statement that people with disabilities had been denied housing in the past because of misperceptions, ignorance, and outright prejudice. And they wanted to make sure that these amendments made a clear pronouncement of a national commitment to end the unnecessary exclusion of persons with disabilities from the American mainstream. And again, it's really essential that people have these rights to make it so that they can live independently and live within their communities. The Fair Housing Act repudiates the use of stereotypes and ignorance, and mandates that people with disabilities be considered as individuals, that generalized perceptions about disabilities are unfounded speculations about threats to safety are specifically rejected as grounds to justify excluding from housing or housing programs. So it really isn't, it really is about equal access to and benefit from housing by affirmatively enhancing the quality of life for people with disabilities and providing that equal opportunity to use and enjoy dwelling. We're going to talk about accommodations and modifications, and those really are removing barriers, not special privileges. So it really is about enhancing and affirmatively enhancing quality of life for people with disabilities. So under the Fair Housing Act, a person with a disability is defined as any person who has a physical or mental impairment that substantially limits one or more major life activities, has a record of such an impairment, or is regarded as having an impairment. So we're talking about physical or mental, any kind of physical and mental impairment that substantially limits one or more major life activities. Can be anything from working to walking to learning to any kind of major life activities that you can think of. So you can have that record of an impairment, but what might be a little different under housing discrimination laws than other laws is that you might not have a disability, but if you are being regarded as having that disability, if somebody is treating you like you have a disability, even if you don't have what they think you have, and discriminate against you, you're still covered. There was a case early on in the 80s where a father and son lived together in an apartment, and the father had HIV/AIDS and the son did not. But the landlord found out and started harassing him and started kind of telling all his medical information to the other neighbors, and saying, I wouldn't let your kids play with his kid, that kind of stuff, this dangerous situation. So there was a lot of harassment going on for the kid. And even though the kid didn't have HIV, the kid still won the housing discrimination suit because he was regarded as having the impairment. So that's something to keep in mind too. And it covers all people involved in the house. So not just the people on the lease, it can be children, anybody who lives within the household is covered. Examples of unlawful discrimination based on disability could just be to flat out deny housing based on that disability, or perceived disability. Also unlawful is to ask about specifics about a disability, the nature of the disability, about medication during the application process. Evict because of disability. We have seen cases of that. Misrepresent availability because of somebody's disability, or just to intimidate or harass somebody in their housing. Other examples might include to indicate a preference based on disability. There have been many cases where people have been kind of steered or told that they don't really want to live there based on what a housing provider perceives as a limitation, but it really is up to the person with a disability to decide where they want to live and where they can live. It's really not up to the housing provider. So even just indicating those preferences can be housing discrimination. Zoning ordinance are a big one that we see more based on disability stereotypes. So this might be zoning ordinances that make it so group homes might not be allowed in certain neighborhoods, things like that. So it can go all the way up to that city level. If decisions are being made that creates exclusionary housing practices, that city can be legally liable as well. Other examples are just to discourage or steer based on disability, provide different terms and conditions like we talked about. And then what we'll talk about probably for the most of the rest of the discussion here is just to refuse to make reasonable accommodations and modifications is unlawful discrimination based on disability. So accommodations and modifications, what are they? So the Fair Housing Act mandates that people with disabilities and who have a disability related need to an accommodation of a rule or policy or a modification of the unit should be granted those. And if not, then that could be a refusal of those accommodations or modifications are housing discrimination under the Fair Housing Act. So that accommodation relates to the alteration of a rule, a change of a rule, a policy, practice, or a service. Costs are generally paid by the landlord, whether it's private or public, because there really aren't many costs involved. At most, it might be an accessible parking spot that has to have a sign put up or something like that. So they're either very minimal or there's no cost involved because it's a rule or policy. If it is both an administrative and financial burden, that might be considered unreasonable, but that's going to be very specific for the house based on the different kind of housing providers. What might be unreasonable financially or administratively for a person who manages a sixplex apartment complex is going to be very different from apartment complexes that are, as a company that owns thousands of units across the state, that kind of thing. So that'll be very specific based on the housing provider. But some examples of this are, of course, emotional support animals, where you're asking for a change of a rule, policy, or that policy that they have for animals in the building. But it could also be something like something we see quite often is people receiving Social Security disability payments, and their apartment has a rule that everybody has to pay on the 1st or they incur a late fee. And people with disabilities who, if that's their only income, is this SSDI income that's coming on like the 5th or the 6th, they can ask for a change of that rule so that they can pay when their SSDI check comes in on that 5th or 6th without incurring those fees until that date. So just changing that rule or policy. Modifications really relate to the removal of physical barriers. So this might be adjusting countertop heights, adding a ramp, those kind of things. If it's private owned housing, then the costs are paid by the tenant. The landlord just needs to allow them to make those modifications. If it's something that will drastically change the apartment, like something where you're lowering countertops or removing cabinets, they can allow for money to be put into an escrow account to put it back into how it was before those modifications were made once they move out. But generally, if it's something that can be used, that actually enhances the property itself or the unit itself and can be used without any problems for the next people to move in, then it might not be required to do that. You can contact our office with help with those kind of decisions as well. Costs are paid by tenant and private, but again, if that housing provider receives any kind of money, whether it's in the building of their units or the managing of their units, any kind of federal dollars go into that, then the costs are paid by for the landlord. So that's when that 504 will kick in. We can look into that if it's something where you want to know if your unit is covered by, received any of those federal dollars when it was built. And we can help advocate for you if those modifications should be paid for by the property management themselves. Requests don't have to be in writing. They don't have to use magic words. You don't have to specifically ask for an accommodation. Basically, once you're asking for a change in a rule or policy or removal of physical barriers based on a disability-related need, you're asking for an accommodation or modification. It's always a good idea to put it in writing and to document the results and any kind of further communication you have with your housing provider, but it doesn't have to be in writing. It doesn't have to use specific forms either. It's another thing we see quite a bit. Reasonable means that it doesn't impose that undue financial administrative burden on the housing provider. Again, this is going to be different. It's going to be determined on a case-by-case basis depending on the housing provider's operation. But for an accommodation to be reasonable, there does need to be an identifiable relationship between what is being requested and the individual's disability. So the requested accommodation must be necessary to ameliorate the effects of that disability and provide that person an equal opportunity to use and enjoy that dwelling. Accommodations examples that might be reasonable might be waiving a rule against non-tenants using the laundry room or any other kind of common space area if that's the rule that non-tenants can't use it. Maybe for somebody with a disability who needs help with their laundry or needs a family member to come in and help them use those spaces or just use them themselves, waiving that rule for the person with a disability. Same thing with allowing a tenant to have a live-in aid without necessarily having to put them on the lease, those kind of things, waiving those kind of rules that are already outlined because of a disability-related need. Maybe waiving late charges and penalties when a disability requires early termination of a lease. Or maybe just waiving a requirement of a prior rental history if the nature of that disability made it so that somebody couldn't live on their own, but now they can, that kind of stuff. So it can be any process, any rule or policy that the housing provider is following. If it's a barrier because of a disability related need, you can ask for an accommodation to that rule or policy. This was an example. This is a bigger kind of conciliation amount, and it really had to do with the fact that the woman had years of issues with her housing provider. But this is a recent disability case in Salt Lake City, Utah, where a woman filed a complaint against her housing apartment and against the housing authority, in that case, against Jefferson School Apartments, which was a nonprofit corporation, and they did receive financial assistance. She wanted to have handicapped parking space specifically for her, and they refused to give it to her, as well as being transferred. The nature of her disability worsened in time, and she asked to be transferred to a ground floor unit, and was denied that as well. And then during the complaint process, she was conciliated for $18,000, which is pretty high in this kind of case, but it probably really had to do with the duration of how long she had to live without these accommodations, and the fact that it was a federally funded housing program. And she was transferred to that ground floor unit, given the assigned spot, and got moving expenses as well. So to get an accommodation, it does need to be requested. This is something that a housing provider shouldn't be guessing anyway, or assuming. It really is something that needs to be requested. A request can be made at any time by the person with a disability. It could be made by a family member. It could be by someone else who's acting on behalf of the person, an aide. It could be us as High Plains Fair Housing Center writing a letter, helping you make that accommodation. It can be anybody on behalf of that person. It doesn't have to be in writing. It can be oral, but it is definitely recommended to put the request in writing and then document any outcomes or any further communication about that accommodation request. There are questions about when can an disability-related need be verified. Apparent versus non-apparent disabilities. If the disability and the disability-related need are apparent, there's no need for verification. If somebody has low vision issues and has a seeing eye dog, it's obvious what their disability related need is to have that seeing eye dog live with them and have an accommodation to the pet policy. If it's something that's not apparent, perhaps like having an emotional support animal where maybe that mental disability isn't apparent, they can ask for verification of it. Verification only needs to be enough to the extent to verify that there is a disability and the accommodation is needed, or that there's a nexus. It doesn't have to go into the details. It can, if that's your choice, but it doesn't have to go into the details of your disability, or those exactly what limitations you might have, or what those barriers are doing. Verification of the disability can be from a medical provider. It can be from a licensed health provider. It could be from a professional representing a social service agency, a peer support clinic, non-medical service agency, really any reliable third party in a position to know about the individual's disability could also provide verification of a disability. In some cases, it might be the person with a disability who can provide verification of that through forms, things that they might be willing to disclose or show. So really, it doesn't have to be a specific form. It doesn't have to be by your primary health provider or something like that. So if you're running into those kind of issues, please give us a call and we can help you work through that. You can't, a housing provider cannot acquire confidential medical records or inquire about the nature or severity of a person's disability. This is a concerning one that we do see quite a bit in North Dakota, where especially with emotional support animals, where somebody is being asked to fill out a specific form, and we come to find out on that form that they have basically signed away their HIPAA rights, and they have given the landlord permission to talk to their doctor about the disability, and that is, HUD says that is not okay, that is too intrusive. So that's something that they cannot acquire your confidential medical records. They also can't do things that might be intimidating, with the purpose of intimidating a healthcare provider or whoever's doing the verification, where you can't require a healthcare provider to testify in court or sign a statement under penalty of perjury, because most doctors just can't sign those kind of forms due to their hospital policies or their clinic policies as well. Another thing we have seen, which is a bit egregious and kind of out there, but we have seen forms where doctors have, like, on the form, it's requiring the doctor to take financial responsibility for any damages that the animal might do. And of course, that's just there to make it so the doctor won't sign, because nobody would sign that kind of a form. So again, if it's a specific form that's being required, please reach out to us and we can help with that, because it doesn't need to be a specific form. A housing provider can deny a request if that request was never made. So this is something where if you are in need of an emotional support animal, don't just get it and have it and not request that reasonable accommodation. So it does need to be made on or on behalf of the person with a disability. It can be denied if there is no disability related need for an accommodation. So if what the person is asking for doesn't alleviate or ameliorate the effects of one of their disability symptoms. The accommodation could not be reasonable if it imposes that undue or financial administrative burden, or just causes a fundamental alteration of the nature of the program, something that goes beyond what a housing provider should provide. And it can be not reasonable if the tenancy of a resident poses a direct threat. So again, not because of their disability, but if there is proof that that resident poses a direct threat to the health and safety of other individuals, it may be denied unless that threat can be eliminated or reduced significantly by a reasonable accommodation. So talking a bit about assistance animals, because this is always a big one in housing with accommodations. Assistance animals are often referred to as service animals, emotional support animals, therapy animals, comfort animals. Under the Fair Housing Act, it's all the same. If it's something that is needed for, if it has a disability related need and they're asking for that accommodation in whatever the pet policy is, whether it's having a pet, having no animals allowed and you're asking for that accommodation, or having animals allowed but having pet rent and you're asking for that accommodation to not pay that pet rent. It doesn't matter what the animal is called. We've had cases where people were denied their emotional support animal because their letter from their medical provider called it a therapy animal instead of an emotional support animal. So they said, well, that's not covered, but they outlined why that person needed it based on a disability related need in that letter. So again, doesn't matter what they're called. Assistance animals are not pets. They're animals that work, provide assistance, or perform tasks for the benefit of a person with a disability, or provide emotional support that alleviates one or more symptoms or effects of a person's disability. It's not just dogs. In this case, it can include cats, birds, guinea pigs, any kind of animal, as long as there's that disability related need for that animal. This is different from ADA regulations, where in public spaces where it must be a dog, usually a dog, maybe a miniature horse, who is trained for a specific task within the housing. Within your housing, it's different, covered under the Fair Housing Act, and it doesn't matter whether it's a trained animal for a specific task or an animal that alleviates a mental disability or an emotional disability. Assistance animals must be permitted for individuals with disabilities by both the Fair Housing Act and Section 504 when there is a relationship between a person's disability and the assistance that is provided by the animal. So there's that nexus. Pet policies should clearly state that the policy does not apply to service animals if they have specific pet policy forms that have very specific things about pet rent, other things like that. They shouldn't apply to assistance animals. Housing providers may encourage licensing that are in accordance with any other local laws. They can apply reasonable health and safety concerns, including ensuring that the individual animals are not a threat or nuisance, but they can apply blanket safety concerns by like breed restrictions or size restrictions or something like that. It really has to be that individual animal being a threat or nuisance that they can apply those health and safety concerns in the situation. They can require owners to clean up after animals and maintain control of animals for sure. It can be written up if they are not picking up after the animal, they can still be written up if they're not maintaining control of the animal. If it is something where a physical limitation keeps it from the person being able to clean up after the animal right away, part of that interactive process of obtaining a reasonable accommodation could be having it for them that somebody can come once a day, or when their aide comes, they can go out then and pick up all the after the animal if there's that disability related need. Housing providers cannot charge a pet deposit or a security fee deposit for assistance animals. So even if they require it for pets in their buildings, they can't charge it to an assistance animal or an emotional support animal. They can't require verification of licensure or inoculations as a condition of approval. This one's kind of a tricky one because the city might require it, right? And they can encourage it if it's based on the city, and then still having to do it. But I couldn't quite figure out how this played out in losing a housing opportunity. And there was a client a couple of years ago who called, and I was working with him, and he had an emotional support animal, was moving. So he had another apartment lined up. His lease was up in a month, and his emotional support animal passed away. So he got a puppy before he moved. And so when he was getting ready to move, he let them know, I don't have that animal, I now have a puppy. The housing provider said, well, you can't have that puppy live here if they're not inoculated. The puppy was just a puppy and hadn't had all of its shots yet at that point. So they refused him the housing, and he lost that housing opportunity because they were basing the housing on that inoculation. So that's kind of how that could play out. Not that he had any intent to not have the dog have its shots, but it just wasn't time for the dog to have all of their shots completed. Housing provider may also not deny access to housing or indoor or outdoor public and common use areas associated with housing with the animal, or impose those breed, weight, or size limitation. There are, I know there's at least one, but I think still another community in North Dakota might has breed restrictions, and those reasonable accommodations can be asked for at the city level. So if there is breed restrictions in the city of, let's say, pit bulls or Rottweilers, and your service animal is a pit bull or Rottweiler, you can ask for that accommodation to that city rule if there's a disability related need for you to have that animal. Housing providers can deny a request if, again, that specific animal poses a direct threat to the health and safety of others, or would result in substantial physical damage to the property. It really is an individualized assessment that must be based on recent, credible, and objective evidence related to the specific animal's conduct, not speculation about the type or breed of an animal. The housing provider can deny it if they can demonstrate that undue financial and administrative burden. That's generally a high standard to meet in case of an assistance animal, but if they can show that, they can deny it. Or if it would create a fundamental alteration, again, kind of a higher standard to meet, but this is in the end a reasonable accommodation. So those same things that apply to reasonable accommodations apply in the case of assistance animals. HUD did put out a more recent guidance on their website. We have it on our website too. This not too much change, but it does address more modern questions like online providers and things like that. So that is addressed within their newest HUD guidance. It's really a simple way to kind of just learn what can and can't be done under the Fair Housing Act. And it really is a kind of a question. I don't know if you can see it on the slide here, but it kind of goes in a flowcharty kind of way where it's, is it a dog? If yes, go to the next question, that kind of thing. So they really took their guidance and clarified it more than even what they had before. So suggest people reference that as well. Couple case examples that did go to court that were larger case examples when it comes to emotional support animals. College housing is covered under Fair Housing Act as well. So college housing does have to allow accommodations and modifications based on a disability related need. And there was a case in 2015 against the University of Nebraska where 2 students were refused emotional support animals based on that disability related need that they needed. And it was a pretty big settlement, and the university was required to change their policy on emotional support animals. In Minnesota, there was a case with a private housing provider where a veteran with war-related PTSD and major depression was denied an emotional support dog based on animal type and weight restriction. And in that case, it was a $19,000 civil penalty because of the lost housing opportunity. And in Montana, there was a case where a landlord required pet deposits for service and emotional support animals. And that was found to be illegal under the Fair Housing Act in that case. And that resulted in quite a bit of money, $11,000 in compensatory damages for the plaintiff, as well as $20,000 in punitive damages. So that's kind of all I have to say about reasonable accommodations and modifications. I do want to touch a little bit on design and construction requirements, but any questions on emotional support animals or modifications and accommodations in housing?
Anything in the chat?
Okay. Sounds good. We have plenty of time, so feel free to stop and ask for questions.
Okay.
We just have a few more slides here left. So in addition to allowing for reasonable accommodations and modifications in housing for people with disabilities under the Fair Housing Act, there's also requirements for units to be covered by specific design and construction requirements. Again, this was amended in 1988 to add disability protections, and part of that was to make sure that multifamily dwellings that are built for first occupancy shortly after the amendments were passed, so in March of 1991, that they contained physical accessibility structures. They were built with physical accessibility in mind within the unit and within the building and around the building itself. So covered multifamily dwellings include any housing that is built for rental or sale, whether it's public or private, and is a multifamily unit that was constructed after March of 1991. So it's any building that contains 4 or more units. If the building has an elevator, then all of the ground floor units are required to have these design and construction standards met. If the building does not have, if it has an elevator, all of the units are covered. If the building does not have an elevator, then it's just a ground floor unit. Sorry about that. Ground floor is the first level of dwelling, something we are seeing more, I think, everywhere. Definitely Grand Forks, Bismarck, Fargo, and Minot, where there are apartments that are built over shops. So that ground floor is not where the shops are. That ground floor is actually that first level where people live. So those are the ones that have to be built with these design and construction requirements for accessibility in mind. There's 7 safe harbors or 7 design and construction requirements that builders and property managers must follow. And this is briefly, we do have a whole coming up in the fall. We have a good 2-hour section class if you want to join us for that on design and construction, going more into the details. But there really does need to be an accessible entrance and a route. Physically accessible to the building. So there needs to be curb cuts. If there are only stairs going up to a building, there needs to be a ramp, those kind of things. So making sure the entrance and routes around the building to the mailboxes, those kind of things are accessible. If there's any kind of facility that can be used by all people within the complex, that must also be on an accessible route so everybody can get to it. Having accessible public and common use areas is covered as well as having usable doors. So making sure that door handles are usable, they not turn type handles, but kind of the lever type handles, things like that, making sure doors are wide enough for people in wheelchairs to get through, making sure there is an accessible route so that hallways and corners are wide enough that people in wheelchairs can get through into and throughout the dwelling, making sure that light switches, electrical outlets, thermostats, and environmental controls are within reach, so not too high for somebody in a sitting position and not too low for them to have to bend over and use a electrical outlet. Walls in the bathroom need to be reinforced. Again, if it's an elevator, all the units must have reinforced walls in the bathrooms. If there's no elevator in the building, then it's the first floor. And then usable kitchens and bathrooms. So bathrooms and kitchens that have enough clearance space so people can get in and maneuver in a wheelchair or with some other physical mobility device. Maintenance of accessible features. If it is something that a landlord would normally maintain. Like if they normally shovel snow off of a sidewalk, then they should also be shoveling snow off of a ramp, that kind of thing. One thing we see a lot of in the winter is landlords either using the accessible parking spot for piles of snow to pile up their snow, or not clearing it out, or not clearing out the curb cut when they shovel the snow, that kind of thing. So those do need to be maintained just like every other parking spot, or other sidewalk feature, that kind of stuff. So if it's something that all people can use, and it's something that is normally maintained by the unit, then they are responsible for the maintenance of it. There were a few cases. I think I have time to go through some of them here. Some of our more recent cases that we see, reasonable modification did not delay or denial. This was a case in Fargo where a woman was in a wheelchair, and she was worried about damaging her stove because she had a stove, and then right next to the stove was a dishwasher. But to use her stove, she had to pull up along the edge, and her wheelchair was hitting the bottom plate of the stove and causing damage. And she was worried about being charged for that damage. So she asked if the dishwasher, which was right next to the stove, could be removed so that she could pull in and use the stove easier and not cause that damage. She was denied that. And then when she tried to move out, she was being charged for that damage after requesting that for over 2 years. So we were able to intervene in that case and help her in that case as well. In Fargo, there was a case where a woman, due to a declining medical condition that she had, she needed to put in grab bars in the bathrooms, and she was told that she was on the 3rd floor, and they said, well, the walls are not reinforced in your unit, so you can do that, but you're going to have to pay for the reinforcement of the wall. So you're going to have to pay for basically the remodeling of the bathroom, which if she was on the 3rd floor in a building without an elevator, it's not required to have those reinforced walls. So maybe she could ask to be moved to the 1st floor unit or something like that. However, talking to her and working with her, we discovered she was in a building with an elevator, and those walls should have been reinforced when it was built. So it was up to the property manager at that time, even though they didn't build the place or weren't the property managers when they built it. It was up to them to reinforce her walls and make sure that it was built the way it was without her paying for it. So that was a case we had in Fargo. There was cases in Grand Forks where we had people were denying reasonable modifications. This was particularly a unit in Grand Forks where a person needed he had the MS and he was having trouble. He was starting to have trouble getting into the tub. So he just needed a walk-in shower. And they didn't believe that he had enough trouble. So even though he had the verification, they delayed it for a while. And then when they finally did it, they said, fine, but you're going to have to pay for it. And when we did our investigation, we realized that they did receive federal dollars and it was up to them to pay for it. So we helped with that kind of advocacy. There was a story in Dickinson where a person with a mental disability, he had pretty severe autism, and his housing provider was really harassing him quite a bit, and he just didn't feel comfortable, so he started recording it. And listening to those recordings, it was very, very much being harassed because of his mental disability. And so in that case, and he was told that that the landlord was never going to rent to people like him again. He was tired of dealing with people with disabilities. And in that case, we were able to help him file a complaint and make sure that landlord adopted different policies and adhered to Fair Housing Act. A lot of emotional support animal barriers that we have seen and do still see are these kind of intrusive or extra forms that are being required of people beyond other types of verification, extra steps, just creating more barriers, telling people that they can have it if they just do this, and then they move into the unit and well, now you might have submitted that from your doctor, but now we need this form, or now we need this to happen, those kind of things. So just kind of providing those kind of extra steps to kind of make you just give up and pay the pet fee. Again, we talked about that waiving of HIPAA rights, very problematic. again, if there's specific forms that you're being told you have to fill out, give us a call. And then there is quite a bit of harassment based on emotional support animals as well. It is a contentious area of fair housing. From both sides, there is abuse on both sides for sure. But if there is a disability related need, you should absolutely get to have it in your housing. I did want to just briefly mention that we do have a testing program where we use testers. So we send in testers. Maybe we send in a tester who has a disability and doesn't have a disability, and on paper they're the same. But we think that a housing provider, or been tipped that a housing provider is using discrimination against people with disabilities. So we can send these testers in. They should be qualified the same, but see if they're being treated differently because of that protected class. Same thing, we could do that for color. We do that for families with children, sex, men, women, that kind of stuff. LGBTQ status. We have testers of all kinds. Testers really are part of an investigation to see whether people experience different treatment based on protected classes. And it really is gathering evidence. It's very objective. Testers who experience discrimination do have standing to pursue a complaint. But it's something that we can use either to help somebody's complaint. We can help them, they can give them that evidence to use in their complaint that yes, this was discrimination, not just a misunderstanding, because this is their practice and their policy. As well as it could be something that we use if people don't want to file a complaint, but they just want the discriminatory action to stop. We can use our testers, and then we can file the complaint to make that housing provider change their policy or practices. So there's that two types: complaint-based testing, where somebody might have a complaint and we can go in with that specific scenario in mind and see if that's actually their practice, and to collaborate those claims against a specific housing provider. Or we can just do systemic testing, looking at tests for a specific kind of discrimination and look for those systemic patterns of discrimination, whether it's in the state or within a community or from a larger housing provider who provides different places, and see if are they systemically keeping people because of their race, color, national origin, religion, sex, disability status, or familial status out of their housing, or restricting their housing and restricting their access to communities. It is something that is necessary because it really collects that objective information. The Supreme Court has approved it back in the early 80s. It's gone all the way through the Supreme Court. It's something that HUD and the Justice Department themselves do. And it's something that Dr. Martin Luther King Jr. did in 1966 as well, as part of pushing for why the Fair Housing Act was needed. So that kind of pretty much concludes this Wednesday webinar. Just a recap of what is prohibited. Again, these are straight from the Fair Housing Act. Refuse to sell or rent a dwelling because of those protected classes, or otherwise make available a dwelling, to discriminate in those terms and conditions of a dwelling. I didn't talk about this, but to have discriminatory advertising is also illegal under the Fair Housing Act. Misrepresenting availability of a dwelling, steering, also illegal. Things like definitely when it comes to people with disabilities, refusing to permit an accommodation or modification is considered illegal housing discrimination, as well as failing to design or construct the multifamily housing with certain accessibility feature. Again, it's all housing transactions, so it could be in the financing of residential real estate transactions or the provision of brokerage services. And then that harassment piece is in there as well. Oh, it stopped moving. Right. So there are some national resources that you can go to. The National Fair Housing Alliance is a great one, as well as HUD. HUD has their own Fair Housing and Equal Opportunity Office. You can find lots of information on the HUD website. The Justice Department has a lot of their cases if you want to see what housing discrimination cases at the federal level look like. But if you go to our website too, here in North Dakota, we are here to help you. You can call us, you can email us, you can submit a form on our website, and we can get you the information if you want to advocate for yourself or somebody else, or we can help advocate for you in your housing situation. There are lots of resources on our website as well. I always try to get people, if looking for those HUD DOJ statements that we talked about with the service animals, those are on our website as well. So good to also have an events tab there to the right of our resources tab, where you can find our future webinars and trainings all over the state of North Dakota. And you can sign up for a newsletter too if you want to hear what kind of cases we are helping advocate for, or any lawsuits that we're involved in as well. So remember, it's not an option, it is the law. These are rights that you have protected under federal law. And you do have ways to exercise those rights, and you have protections when you exercise them from retaliation. If something just doesn't seem right in your housing situation, give us a call. This is our intake number, 701-203-1077. You can email us, you can go to our website. There's a form you can click on our website to contact us, and we'll have a housing intake specialist give you a call back to discuss your housing situation. You can message us on Facebook, however you need to get a hold of us. We're happy to help you in your housing situation. And that is it.
Perfect, thank you. Hey, so maybe I misunderstood when you were saying, and this was at the beginning, but you talked about, so they can't discriminate if you're using a housing voucher, correct?
It's so they might not accept it because of their business policy. There might be something where they don't accept it, but to have blanket statements where we don't accept housing vouchers could be that discriminate, whether they're advertising it or not. Just to have that blanket statement.
Okay,
Is
is
a
it
little
okay?
discrimination.
Right.
Yeah. So if
Okay.
it's something where they're just refusing it, if there's a legitimate business reason, they might be able to, but they really just can't refuse blanket statements. We're not going to take that, or charge people with vouchers higher prices and things like that, or make the application process different.
Okay, yes, thank you for clarifying that.
Yeah.
Okay. Awesome, because I think we've seen that a few times with people we've tried transitioning out of the state hospital, and then they're on a housing voucher, and then we see them having problems getting into places because of that voucher. So
I would give us a call anyway. We
Okay.
do see where, especially if it's specific kind of housing vouchers, like the housing for people with AIDS, people who've been hospitalized, if it might actually be disability discrimination, not because of the voucher. So it's always worth giving us a call to do a little more investigation and finding out.
Sure. Awesome. I
Yeah.
assume you guys don't charge fees for.
We do not charge.
Okay.
No, that's a good point to make. Yes. So everything we do, I didn't put this slide up, but we do receive HUD grants to help people and to do education and outreach and that kind of stuff. So
Hey,
yes.
Kelly, I have a question for you. I've been told recently, and I kind of had heard this before, but that there's a certain property management place in Bismarck that is making people who have a criminal history pay 4 months rent up front, 4 to 6 months up front, before that they'll rent them. And according to Center Code, they can only charge 2 months. Is there anything that you could do for like protective class on that?
There might be. I would suggest calling. That's probably more of a landlord tenant issue, not a fair housing issue. I could probably go off on a tangent about how I think criminal background policies might be a fair housing issue. But in that case, that could be something where it's more of a landlord tenant legal question. Because you're right, it does say in our century code that you can charge 2 months rent, but not more.
I mean, would you ever send people over there to see if to confirm that, your shoppers?
So we have things that we have seen with criminal backgrounds, and you can certainly let us know. Often if there's one unscrupulous practice, there's other ones as well, right? But we do see with criminal background checks where people are treated differently because of their race or because of a disability status. And
right,
something
with that criminal background, right?
What's that?
With that criminal background as well.
Right.
Yeah. And Kelly, I didn't realize this, but I knew you from before, and it just hit me because we met at that conference.
Yes.
Yes, and I'm like, wait, I know her. I feel so stupid. I knew she was in Bismarck, so sorry about that. But I will get in touch with you privately to see if there's something that you can do about that.
Yep. And another thing to keep in mind too, if you could ask for reasonable accommodation if part of that criminal activity was for an undiagnosed at the time, or was because of a disability that was involved in that having that crime, right? And something that might have been undiagnosed and now you're getting treatment for. So that could be a policy that could be a reasonable accommodation asked for based on disability related need.
From what I've heard, I think it's more of a race thing and criminal thing, but I'll talk to you about it.
Okay, sounds good.
Thanks, lady.
Thank you.
Anyone else have any questions? Let's see. Last call for questions. That was great information though. Thank you so much for sharing. It's frustrating, those situations you guys have to deal with. But
The more people know their rights, and can exercise them, the better for
exactly.
everyone.
Yeah.
So thank you for having us here.
Yes, thank you. All right, awesome.